I believe we are live.
We are live, okay. Welcome you to the afternoon settings, the May 5th, 2021 afternoon settings of the Seventh Court of Appeals via Zoom. We have the justices that are appearing on this panel, Justice Pirtle, Justice Parker, and myself, Brian Quinn. We will go on and call the docket, and I see the faces there of the attorneys, so they should be ready, but we'll go on and call the docket. It's 07-20-00168-CV, Vicki Allred and Charles Allred versus Freestone County Fair Association, Inc. and others. Mr. Alexander, are you ready?
Yes, I am, Your Honor. Thank you.
And Mr. Bellevue, you ready?
Yes, Your Honor, I'm ready.
And as I understand it, you've been granted an extended time for argument. Each side has been granted 30 minutes instead of the 20-minute usual. And the appellants are going to have just the usual 5-minute rebuttal. Is that your understanding?
Yes, it is, Your Honor.
Yes, it is, Your Honor.
Okay. With that said, Mr. Alexander.
Thank you. May it please the court. In my 30 minutes, I hope to cover 3 different topics. First, I'll demonstrate to the court that the exclusion of the testimony of plaintiff's expert, Rafe Foreman, skewed the trial of this case to such an extent as to make it reversibly harmful. Second, I'll demonstrate that Mr. Foreman was fully qualified by his experience under Rule 702 to testify as an expert. And finally, I'll demonstrate that the defendant's reliance upon the Farm Animal Liability Act to excuse their liability for this incident fails. To create context for each of these arguments, I'd like to begin by showing to the court the video of the incident. And when you're watching the video, you'll see that this is not the usual case where there's a contest with the light red with the light green. This is not a case where we have to have accident reconstructionists tell us exactly what happened. You'll see the entire incident. You'll hear the sound of the wind. You'll see as Tutor Allred goes around the third barrel, the tarp that's flapping in the wind. And then finally, you will actually see the closing of the gate itself. So with that, let's go ahead and watch the video. So your honors, because this is a case where none of the facts are contested, where we don't have any questions about what actually happened, what did this case end up being about? It ended up being entirely about what could have been done or should have been done to prevent what you just saw happening. That turned out to be the entire issue in the case, and that underscores precisely why expert testimony was so critical. What happened by virtue of excluding the testimony of plaintiff's expert, Ray Foreman, is that defendants were able to create the impression that what you just saw was an unavoidable accident, that what occurred to Tutor Allred as she was crashed into by that gate was an inherent risk of barrel racing. That was the inevitable finding of the trial judge in issuing an instruction on unavoidable accident. But if Mr. Foreman had been able to testify, this would have been a different trial. I'm going to demonstrate that now by showing you the 5 ways in which he would have testified that this that this incident could have been avoided. This was not an unavoidable accident. So if we can go ahead and see the banner. What you see here is the banner on the gate that you just saw being closed. What Mr. Foreman would have said is the first way to avoid this incident would have been not to put an 8-foot long banner on this 14-foot, 600-pound gate. that what that did was to create a sail that in the wind allowed a gate that could be opened or closed by just one person to do what you just saw it do.
Mr. Alexander, let me stop you quickly. In the briefs, the photos or in the record, the photos have a date stamp that is a year later. And I can't see it on my screen here, whether this has that same date stamp. Are these, 2018. Accident was 2017. Does the record reflect that this is the same sign, or is this a similar sign, or do we know the circumstances around this creation of this photograph?
No, that's a great question. This was taken a year later. This is the same gate. This is the same site, advertised in the same radio station. So everybody agrees that what you're looking at here is as it was on the date of the incident.
Okay.
And so the first thing that could have been done was not to put the sign up in the first place. Now they said, because they didn't have the testimony of Ray Foreman to contend with, that no. You always put the sign up. In fact, it's done for safety reasons. That what these banners do is they create a barrier for any cattle or horses that are in the arena, and that therefore that's what makes them safe. They're not able to see through the rails. Now, the problem with that is Mr. Foreman would have been able to testify, and you can see it yourselves on the video. When you looked at that arena, 75, 80% of it did not have any signs. So that was a bogus explanation as to why they had to have the sign up for safety reasons. The second thing he would have testified to is if you nonetheless want to keep the sign up, then you need to put wind cuts in it. That way, when the wind blows, as you heard it blowing at the time, it'll blow through the sign rather than blow the gate shut. Now,
is there record evidence to indicate which direction the wind was blowing and the velocity of the wind?
Well, those are two questions. I'll break it down. We know that the wind was blowing in the direction of this sign simply because physically we are actually seeing it close. So it's reasonable to conclude that this was everybody agrees that it blew shut by the wind. That's not contested. As for the wind speed, that was evidence that was excluded. So we were, and we say erroneously excluded, but nonetheless, you could hear the wind, you could see the tarp that was flapping. We know that it was a windy day. And we know that wind cuts would have prevented this from happening. The third thing that he would have testified to is that if you don't want to put wind cuts in the sign, post a gate man at the end of that gate to the far right as you're looking there. Someone who can hold it, who can prevent it from doing what it indisputably did. Now, once again, the other side had a safety explanation as to why you supposedly couldn't do that. They said, well, if the horse is charging out at 30 miles per hour, you don't want somebody standing there. The question came up, well, just stand on the other side. They're in the bucking chute. And I believe it was Sid Fryer testified, well, you can't do that because that would create the safety issues because that's where we keep the bulls. Well, once again, Ray Foreman could have explained this was being run on a Saturday in the slack. There were no bulls in that chute. There was nothing to prevent somebody from being just right across that fence, holding it in place that would have indisputably have prevented this incident from occurring. The fourth thing that could have been done, even without a gate man, is that the gate could have been tied back. And this became critical testimony in the trial. If you look at the gate there at the end, circling, there's a little tab. And we'll now take a closer look at that. It's a rather blurry photograph, but Ray Foreman described that tab saying there's a little groove in it, so that all you have to do is tie one end of a nylon rope to the railing of the fence right there, and the other end make a little knot and just drop it in that groove. The reason that's important is that the other side insisted that this gate needed to be closed quickly if there was an accident in the arena. Well, in the way Ray Foreman would describe it, you just race to the gate, it pops right out. It's quote unquote a simple thing to do. So the final thing that could have been done, the fifth thing, to prevent this incident from occurring is to do what Jimmy Allred should have done in the circumstances of this case. With this gate in this condition and with that wind that you heard, simply stop everything. Don't allow that race to occur. So this was testimony that the jury was deprived of the opportunity to hear, and what it allowed the defense to do was to create a Hobson's choice. They called it more colloquially, and you'll see it in the testimony, the danged if you do, danged if you don't argument.
Counsel, I've got a question with regard to the tab that you just mentioned. Somebody put it on there for some purpose? Somebody put that tab on there for some purpose?
Oh, yes. No, that tab is...
Okay, for instance, if they're riding bulls out there, they want all the gates closed?
Yes.
They close that gate?
Yes.
How do they keep it closed?
Well, that interesting you should ask with bulls. With bulls, that gate, and this is actually in the briefing of the defendants, with bulls, you have that gate closed as the bull is bucking.
Right.
And then as soon as that event's over, you open up the gate. So there's a gate man standing there to open it.
That's my question. How do they keep it closed? The gate man, somebody standing behind it?
That's my understanding, is that you actually have a gate man who is there holding the gate. That's my understanding.
So it's not in any way chained or roped or anything. It's just somebody holding.
Well, there is, again, with that notch, I think that you could have a chain to do it. And again, you could just flip it off and open it. So I'm not sure. I can't tell you with certainty because there's no testimony about it. But either there would be a chain that would go in that little groove. You just pop it up and open it when the bull needs to come out, or you simply have a gate man posted who, when it's time for the bull to get out of the arena, you open it up.
So it's not far-fetched to have somebody behind the gate to work the gate?
Absolutely not. Okay. Absolutely not far-fetched at all. And in fact, Ray Foreman has testified that one of his tasks was to be that person, the gate man. So
the video itself also shows a gentleman inside the arena. What's his function?
The gentleman inside the arena is actually the judge. I mean, that's what you're seeing is my understanding that is the judge. So yeah, you have people inside the arena.
Yeah.
Okay, just again, for the sake of example, let's go back to the bull thing.
Okay.
Why would you want to close that gate when the bull's over there? I mean, you have a purpose to close it to keep the bull from going through it, basically, correct?
Yeah. Okay. So in the case of the bull, you have the bull chute is right next to that gate. Are you with me? That's called the bucking chute.
Right.
And so what'll happen is somebody will open that gate, and either the bucking bronco or the bucking bull will come out and will do their thing. And then at the end, the clown, the funny man, the clown comes out to get the bull away from the person on the ground. And then meanwhile, the fellow with the gate goes and opens up the gate so that they can shoo the bull out of the arena.
But part of the bull event, when the bull and the rider are actually in there, is closing that gate.
Correct.
Okay.
That's absolutely correct.
Okay. To do a barrel race is part of the event opening the gate that the rider leads through and goes back in?
No, that's a great question. For the bull event, that gate remains open at all times. That's the purpose of the gate in the barrel race. Let me make sure I got this right. In the barrel race, when the rider races out of the arena, as you saw Tutor Allred do, that gate is in the open position.
Correct.
Okay. And when at the very end you race out, that's also in the open position.
So part of that event is the requirement that the gate be open for that event to function properly.
Correct.
Because you can't exit through a closed gate, correct?
You cannot exit through a closed gate.
Okay.
Okay.
So is there any dispute anybody dispute that the gate had to be open for the event to begin and to end?
No.
Okay. Thank you.
And so the only dispute was when it's in the open position, is there something needs to be done to make sure that it doesn't close during the event so that you have what happened here. And as I said, that ended up being the danged if you do, danged if you don't defense, which I'll explain to you now. Without the testimony of Ray Foreman, the trial devolved into this curious dispute about who is it that we can save? Who can we protect? If we tie the gate open, that's going to protect the Tudor Allreds of the world. That is, the person, protect them from having the gate close on them as they're exiting the arena. But if you do that, then you're not protecting someone in the arena if they fall down and start getting drugged. And they say, and that happens more often. What happened to Tudor Allred getting hit by a gate is very rare. What happens all the time is people go down the arena, you need to close the gate. So it was this Hobson's choice. We could either protect the one or the other.
Counsel, if part of the event is the gate being opened, the barrel race, is the gate being opened, and I'm assuming the defense argued, well, we don't have to chain it. We don't have to put a banner in there that does not allow the wind to make it sail. How do they assure, or how did defense explain that they assure the gate stays open?
Well, that's the problem. You've hit the nail on the head.
Is it just hopefully we pray that the gate stays open?
Yes.
Okay.
Yes. I mean, the part that's so disturbing about it is they say that's true going forward too. They say this is just an inherent risk of barrel racing. It's an inherent risk that in a race of this type on a windy day, it rarely happens, but it may, and you're injured. They say that that's an inherent risk. What Ray Foreman says is that is absolutely not the case, that you don't have to have this Hobson's choice. You can protect both. You can protect the person who's racing from having the gate close on them by doing one of the 5 things that I've just outlined. And you can protect the person, even if one of those things you choose is tying the gate, that still can protect the person in the arena, because all you have to do is sprint up to the gate or climb over the fence, pop it open, and there it is.
If it is an inherent risk that the gate may close, does that mean the rodeo promoter would have notice that the gate may close?
I'm sorry, could you repeat that? I didn't quite.
If it is an inherent risk that the gate may close when you're doing a barrel race, does that mean the promoter, being that it's an inherent risk, should know that the gate may close?
Yeah, I mean, it is. I mean, we say that, yeah, I mean, what Ray Foreman would testify is the promoter should know that on a windy day, an unsecured gate will close.
I'm just saying if the defendants are right in saying it's an inherent risk that the gate will close, does that pretty much ipso facto mean they had notice that the gate will close? Or they should have had notice that the gate will close under any circumstance?
I mean, yeah, I mean, I'm not going to make the argument for them. What they
No, I'm saying for premises liability.
Yeah. I mean, what they would like to say is just so I'm clear. I mean, we're shifting out of the Farm Animal Liability Act, which is fine. What they would say is that because what occurred here was an inherent risk of barrel racing, then under the express terms of that statute, they cannot be held liable.
Right.
But what we would argue is, and I can either get into that now or come back to it. I see I have 11 minutes. I'll come back to it a little bit later, I guess, and address that point. demonstrating that that's not an inherent risk. In fact, let me just do that now. Let's go ahead and do the Farm Animal Liability Act aspect of it. They argue that under the black letter of that statute, that if there is a collision, any collision, such as this one, then ipso facto, under the statute, that's an inherent risk and there's no liability. The case that you need to look at that completely rebuts that conclusion is the Texas Supreme Court's case in Loftin, Loftin. It's in our briefs. It's a decision by Chief Justice Hecht, and he provides these hypotheticals that are very helpful, saying that no, not every collision, not every crash is going to be an inherent risk. He gives this great example of one that would be, that I think illuminates things here. He says, you know, if you're just out at an event and a car crashes into you, that's not an inherent risk under the act. But if you're backing your trailer, horse trailer, into an area where everybody parks their horse trailers, okay, you can reasonably expect that there's going to be other moving horse trailers. And in that situation, if you are hit by a moving horse trailer, that's an inherent risk. That's something you can expect to happen, even if the person was negligent. Okay. Okay. So let's take that and tease that out. In this case, if you look at the testimony of Jimmy Adams, he himself said, agreed, this is not something, no, this is something you should never see. What we just saw in the video is something you should never see in a barrel race. It's not an expectation. There's no expectation that when you're running a barrel race, this gate's going to close into you. Unlike Chief Justice Hecht's example, where you can expect, if you're trailing your horse into an equine event where other people are doing the same, you can expect that there's going to be moving trailers. You better be watching out for them. And if somebody's negligent and hits you, that's on you. Okay, this is not that case. The notion, in fact, you can look at the example that they provide. They try to have it both ways. They go on to talk about the exception to the inherent risk rule, which is that if you have faulty equipment in an animal event, then there can be liability. What they say is, well, but the gate is not involved. This is back to your question, Chief Justice Quinn. The gate is not involved in barrel racing. It is involved in, for instance, the bull riding event. And so therefore, their argument is, this is not a faulty equipment in barrel racing. Well, if you take that to its logical conclusion, then this is an unexpected event that's not an inherent risk. You can't have it both ways. You can't say that the exception does not apply to barrel racing, but the rule does not, or the other way around.
Is the ring equipment considered equipment in a barrel race?
The gate certainly would be. I mean,
Well, that's what I'm saying. You start with the ring,
Yes,
and then
yes.
the gate's part of the ring.
I think that both parties would agree that the gate is in fact equipment. In other words, would both parties agree it's an undefined term under the Act? If you look at Black's Law Dictionary, other dictionaries, Black's Law Dictionary, I'll try to quote it, is that, you know, an article or an implement that's used for a specific purpose. You know, so here you have a gate. It's for purpose of letting cattle in and out. Or in this case, they'll say the purpose is also to save people in the ring. So it is equipment. We would argue that the exception applies. It's part of an animal activity. And the notion that the exception doesn't apply, I think, doesn't bear up under a fair reading of this Act. So it is neither an inherent risk, or even if it is an inherent risk, it is nonetheless faulty equipment that would excuse you from that. So again, this danged if you do, danged if you don't situation only came about by virtue of keeping out Mr. Foreman's testimony. In this case, that was reversible error, but because it was the critical issue in the case, because there was no factual disputes, no reconstruction necessary. The whole thing was about what could you or should you do. Now, why was he excluded? The judge concluded that, I mean, this is kind of curious, he was both underqualified and overqualified. Let's talk about each. On the underqualified side, the idea was, well, you know, he's not a UPRA, United Professional Rodeo Association judge. Therefore, he doesn't have the certifications necessary to be testifying about gate safety. Well, the case you need to look at for that point is Gammill, another Texas Supreme Court case, Gammill. It's cited in our briefs. Another opinion by Chief Justice Hecht. And he quotes a decision by the Sixth Circuit that's very illuminating as to who experts can be. And he uses this, the Sixth Circuit uses this great example. If you want to explain to a jury how it is that a bumblebee can fly, probably need to get an aeronautical engineer. But if the question is, do bumblebees or bees always take off into the wind? He says, get yourself a beekeeper. Well, in this case, Rafe Foreman was the beekeeper. He was someone who, by virtue of his experience, 16 years, 50 events a year, in every position, he's been a judge, an announcer, a gate man, and most importantly, he was the fellow who would go out with a safety team before events in order to see if there's any problems, do repairs. He was a welder. He actually would weld gates. He knows gates. He was the only one who testified at trial to actually having seen a gate close before at a rodeo when it had a banner on it. They said, all we did was tie it back. No problem. It was fixed. I mean, the irony of this case is that whereas the other side ultimately got to have their own expert, Ed Colston, who had been a UPRA judge for 40 years, there was no one in that courtroom who knew as much about gates and gate safety as Rafe Foreman. He was the beekeeper. He should have been allowed to testify. When you read the Gammill opinion, you come inescapably to that conclusion. And by virtue of his not being allowed to testify, this trial was completely unfair to Tudor Allred, and she's entitled to a new trial. Be happy to answer any further questions, or otherwise I'll get back my time. Reserve it for rebuttal.
Question? Thank you, counsel. Mr. Bellevue, you have the floor.
May it please the court, counsel, Ian Bellevue for appellee and cross appellant, Freestone County Fair Association. This case is about a couple of things in our view. And this is a textbook case of a premise owner or occupier not being an insurer of people's safety. It is also an example of just because and something is not foolproof does not mean that it presents an unreasonable risk of harm. It's also a case that involves what discretion is a trial court afforded in making evidentiary determinations. Starting with Mr. Foreman, if you look at his experience is not in a paid position. He was a volunteer parent. He had never been a stock contractor. He did not own any stock. He had never been a rodeo promoter. He had never been in charge of putting on a rodeo. He essentially just helped out where he could in connection with his children participating in rodeos. And although counsel for the appellants would classify him as a beekeeper, I think Judge Jones said it best whenever he was ultimately making his determination that he was not qualified, is that even though he had watched 1,000 football games, he wasn't an expert on the spread offense. And the same thing goes for Mr. Foreman. That's essentially what he did, is he was an observer. And even by his own admission, he followed the directions of other people. He was not the one making ultimate decisions as to what happened. Another thing that I think is instrumental in reviewing the trial court's decision to exclude Mr. Foreman is, as is admitted, he is not involved in any way in rodeos as his profession. His profession is a trial attorney. He'd been an attorney for over 32 years. And in the questioning on voir dire by the Allred's counsel, he went into how many premise liability cases he had handled. Before we ever even went down for his actual voir dire hearing, the trial court had already instructed the parties that Mr. Foreman or no other witness was going to be providing any testimony regarding legal conclusions. But yet, whenever Mr. Foreman was on the stand for voir dire, he readily admitted, I cannot separate my 32 years of experience as a practicing attorney from being an expert and delineate out these legal opinions. So ultimately, I think in addition to him not being qualified, that's something that the trial court looked at, is him invading his province as the one that charges the jury and the rest of the court with the law in the case and pronounces what it is.
Is that more of a Rule 403, risk of prejudice outweighs probative value type situation?
Correct. And I mean, the case law is pretty clear that expert witnesses don't testify on issues of law. And that was the basis for the trial court excluding his testimony on that before we ever even had him on voir dire. And I think that's another thing that the point that came up during the pretrial hearing is, because the trial court knew that there was still going to be a hearing, he instructed the Allred's counsel, do not mention any possibility of Mr. Foreman testifying or any opinions he may have during your opening argument. And now the Allreds come in and complain because in closings, the defense made hay of the fact that Mr. Gerards repeatedly promised that there would be expert testimony during trial, which the court had instructed him not to do. And then the defendants talked about how there was no expert testimony in closings. He was instructed not to do it. But really, if you get down to, and there's a couple of things I want to point out that I think bear noting. Of the 5 things that the Allred's counsel pointed out that Mr. Foreman would have made a difference on, one of them was about there not being any rough stock like bulls in those pens on a Saturday. That is nowhere in the trial court's record. And that is nowhere in any of Mr. Allred's opinions that he had previously was going to offer. Sorry, Mr. Foreman, not Mr. Allred. And the other thing is, there's no evidence and there's nothing in the record that Mr. Foreman was ever going to offer any testimony about the need for the rodeo being stopped. The Allred's counsel questioned people on that during trial about the possibility of it, but that was never an opinion that Mr. Foreman was going to offer. And now let's back up and look at some of these other opinions that he was potentially going to offer. For example, the banner being put on the gate. Just as Mr. Foreman is not a professional rodeo person, he's not an engineer. He had done no calculations, had done nothing to determine what kind of cuts being put on that gate would have prevented this from happening. There's no evidence in the record of what might have been done that could have prevented this from happening. They also talk about,
do you need to be an ex-counsel? Would you need to be an expert to testify that if you put a rope around the end of the gate and tie it to the pen next to it, that it will keep the gate from testifying? I mean, not testifying, closing? Do you need to be an expert to testify to it?
I don't think that you necessarily need to be an expert on that issue, Judge, but you bring up a good point, because even though Mr. Foreman did not get to testify to that, Jackie Yachtslaw, who was there, who the court allowed to testify as a barrel racing expert, she did testify that that would have been a way to close the gate.
Or to keep it open.
Sorry, to keep it open, sorry. And so did Marissa Berger, who was a friend of their families and testified as a disinterested witness and had been participating in barrel races for 30 years. She testified that that would have been a way to keep the gate open. So it's not a situation where there's a void of any evidence on that issue before the court. This isn't a situation that's presented, for example, in the JBS case, where the trial court excluded evidence of the plaintiff having been under the influence, and so the jury didn't get to hear it. The jury got to hear it. They got to hear it from Ms. Yachtslaw. They got to hear it from Ms. Berger. And the same goes for other evidence that Mr. Foreman, would have provided during the trial. If you go and look at their brief and the issues that the plaintiffs complain of, they talk about dangerous condition, that he would have repaired the gate, how the gate could have been secured, that the gate was a dangerous condition with a banner, that there needed to be a gate man. Jackie Yachtslaw testified in rodeos she had participated in, there had been gate men. Carissa Bryant, the Miss Allred's daughter, testified that there had been gate men in rodeos that she had participated in. Marissa Berger, again, testified that there had been gate men in rodeos that she had testified in. So that's, again, it's not a situation where that evidence was not before the court and the jury was not allowed to consider that information. It was. And you look at other things that Miss Yachtslaw testified to. She testified she had never not seen a gate tied back. There's no dispute, she's a world champion barrel racer, been doing it most of her life. She testified that the gate could have easily been tied back. She testified that bylaws required the arenas to be safe. So the testimony that they complain about that Mr. Foreman, who wasn't qualified to testify, would have provided, it got in through other people. And so then you go to an issue of the gate itself and whether or not, ultimately this case was presented under a premise theory. They want to have this both ways, depending on what position they are advancing. Whether they're advancing their theory on premise liability, or they're trying to keep the rodeo and Jason Murray from being entitled to protections afforded by the Farm Animal Activity Act. When it comes to the notion of the premise liability, they say, oh, well, this is something that you should have expected. This is something you should have known was going to happen in a rodeo. But then whenever it comes to the Farm Animal Activity Act, we don't know anything about this. This is not an inherent risk. The possibility of a gate blowing shut is so foreign to us that it couldn't have been what the legislature discussed.
Is your argument then, if they should have known, then it should be an inherent risk?
In Justice Quinn, when you say should have known, are you talking about should have known for purposes of premise liability law?
No, what you had just said. I was trying to follow the argument you were just making when they're trying to have it both ways. They're saying that they should have known that it was going to close, but it's not an inherent risk, which means they didn't know it was going to close or something like that.
So what the plaintiffs want to do in their briefing, and I'll get into the Freestone County Fair Association's position after I answer this, but what the Allreds want this court to do is say that this is a risk that happens in rodeos. Freestone County Fair Association, Jason Murray, everyone else involved should have known about it and should have protected against it. And so it happens in rodeos. They should have known about it, so they should have done something to keep this gate open. On the premise claim, that's their theory.
Right.
But then whenever you go over to the inherent risk thing, they say, well, no, nobody knew that this was going to happen. The idea of a gate closing and there being a collision between it and Tudor Allred is so far-fetched that it doesn't fit within the definition or fall within the collision with an object pronounced in 87.0034.
And your argument is that's inconsistent.
It's completely inconsistent. You can't have it both ways. They can't argue for premise purposes. This was such a known risk that it needed to be protected against, but yet when it comes to inherent risk, that it's so foreign and the idea, is so far out there that the Freestone County Fair Association and Murray shouldn't be afforded that protection.
Okay,
And I
so on your argument, if it is so well known, it should be an inherent risk.
Correct. That's my argument. I'm not saying that it's so well known, but my point is that if you're going to contend that this is a risk that Freestone County Fair Association and Jason Murray should have protected against, then how does it not fall within the expansive view of 87.0034 as a collision with an object?
Would the converse of your argument be true too? If it is an inherent risk, it should have been well known.
No, I don't. I would disagree with that, and that's for a couple of reasons. First, this is a part when reading their brief, I think someone can struggle with, is if there's no wind, as is demonstrated by the evidence in the record, because on Wednesday night during the youth rodeo, this gate never closed, and I think there's testimony that it was open for several hours that evening. Friday night during the rodeo, this gate never closed. Saturday morning, I believe Miss Allred was somewhere in the 23rd to 25th barrel racer to run that morning. This gate had never closed. This gate sitting not tied open with a banner on it in and of itself is not a dangerous condition. This gate only even begins to pose any kind of risk of harm if there's enough wind to blow it shut. And only when there's enough wind does it even begin to pose an unreasonable risk of harm to somebody. But again, Sid Fryer testified. He's been a part of the Freestone County Fair Association for 20 plus years. He'd never heard of this gate blowing shut. It had not blown shut at any point during the rodeo leading up to that point.
Was the wind blowing the day before, et cetera? Is there evidence in the record to indicate the wind was blowing throughout the rodeo, or it started on the morning of the slack competition?
So Justice Quinn, there is no evidence in the record on that point. The only evidence that's in there is that Jason Murray testified that morning that the wind had actually been pretty slack and it blew up. And that's a point that, during the pretrial conference, there was an issue where the plaintiffs had wanted to introduce some evidence that they downloaded, I believe, from Weather Underground or weather.com, from wind data from the Mejia Airport, which was 22 miles as the crow flies from the Freestone County Fair Association grounds. It's kind of interesting because I'll give them one point. I think during the trial, nobody recognized that during pretrial, Judge Jones just said, I'm inclined to exclude it. But the bottom line is he never did exclude it. And on top of that, they never tried to offer it during the evidentiary portion of the trial. So they've waived that point. They never tried to bring it up. It's that data that they downloaded from one of those sites is nowhere in this court's record for it to look at. And on that point, the trial court was correct to exclude it because, as I indicated earlier, that data was from the Mejia Airport, 22 miles away. There was nobody that had even offered any opinions, much less being qualified to offer those opinions, that it being windy at the Mejia Airport meant that it would have been windy at the Freestone County Fairgrounds 22 miles away. So if you look at cumulatively of the testimony that Mr. Foreman allegedly would have brought, but then look at the testimony that was offered by Jackie Yatzlaw, Marissa Berger, Carissa Bryant, they testified to the main points that Mr. Foreman was going to testify to. And that's that they'd seen gates tied open. They'd seen gate men before, and that there would have been an easy way, at least in their mind. And I think it's questionable whether or not their method was appropriate. But you also heard Marissa Berger, or you didn't hear it, but it's in the record, where Marissa Berger, who participated in the same slack run that Miss Allred participated in, she was in the alleyway before this happened, saw the gate moving, and did nothing about it. She didn't even look to see. She said it was moving 2 to 3 inches. She doesn't even look to see whether or not it's tied open. She doesn't even think enough about it. And I don't think that the woman is callous enough to actually do this. She doesn't even mention it to her other competitors. She doesn't mention it to anyone because it wasn't a risk. Nobody thought it was going to blow open. As they like to point out, they say it's a 600-pound gate. That's going to take a lot of wind to blow a 600-pound gate, and they don't have anyone to testify on that. But if you look at going to the Farm Animal Activity Act and going back to that in the Lofton case, I don't think that Mr. Alexander's characterization of what Justice Heck said in that case is exactly what the case said. What he said was that if the plaintiff was leave for a trail ride and got struck by a truck, it would not fall under the purview of what was at that time the Equine Liability Act. However, if they were struck by a horse trailer while unloading their horse, it would have been an inherent risk. He doesn't make any mention of whether or not the truck is moving. I would think most people would have the common sense if you're going to be in a trailer unloading a horse to not try to do it while a vehicle is moving. So in my mind, the only way you're going to really be struck in that scenario is by an internal or external gate on that trailer. Justice Heck does not make a distinction on whether or not the vehicle is moving when that person is unloading the gate. But when you look at the language of the Farm Animal Activity Act, 87.0034 makes no distinction. It just says a collision with an object. It doesn't say that object has to be stationary. It doesn't say one way or the other. It just says a collision with an object. And that's what happened with it. I don't think there's any doubt that that's what happened. They try to say that there wasn't a collision. It was that the gate hit her. I think that's parsing words. I think it's pretty clear that there was a collision between her and the gate. And getting back to something that you'd said earlier, Justice Quinn, and some questions that you're asking Mr. Alexander, the gate here is not instrumental in the barrel run. There could not be a gate there, and she could just as easily still make the run. I think it is instrumental in something more of a rough stock competition where that gate is closed and then it is opened up so that animal can leave after the competition, whether it's bull riding, bareback or saddle bronc, calf roping, bulldogging, one of those things where that animal needs to get out. Then the gate is somewhat used, but here, whether that gate is even there or not makes no difference in whether or not people can participate in barrel racing in that arena.
Do you look, in doing your analysis, do you look at the particular event, or do you look at the overall rodeo in determining whether or not it was equipment or faulty equipment or whatever?
I think you have to look at the particular event. But another thing on that exception to the rule, they pleaded 2 exceptions. The other one was the willful and wanton conduct, but gross negligence was summary judgment was granted on that, and they didn't appeal it. We addressed it in our brief in an abundance of precaution. But if you look at the exception dealing with equipment or tack, it says that the owner of the premise knew or should have known about. There is zero evidence here. Again, they don't really say what makes it faulty. Is it not being locked open? Is it having the banner on it? What exactly is being faulty? They don't really say. And if you look at the snippet that they provided from Mr. Foreman, he just says the gate's faulty. Well, I think we all know that that's just conclusory. That if you just say, oh, well, something's broke, that doesn't get you there. You need to have some kind of stepping stones connecting the dots to say how it's faulty. But here, they never say that it's faulty. And this gets back again to my premise analysis that even with, just like the premise, there has to be a knew or should have known of the condition. There's no evidence that existed with connection to that exception. And honestly, I don't know that Mr. Foreman could have provided that testimony, because he sure can't testify as to what someone else's mental state of mind is to establish actual knowledge. And given the complete absence of any evidence of this gate ever blowing shut before, I don't know that he could have said that someone should have known that it would have happened. Because, I mean, I think we've all experienced things in our lives where it's kind of like something happens, you kind of step back and you're like, whoa, that just happened. You may have done it 100 or 1,000 times in your life before and never seen things fall the way that they did. And that's why I say that this really is a situation where just because something isn't foolproof doesn't make it a condition that poses an unreasonable risk of harm. I don't think anyone disputes that what happened to Miss Allred is tragic. But just because somebody's hurt doesn't mean that somebody else is liable in the eyes of the law. And that's why you have, especially in premise conditions or in premise cases, that's why you have these heightened requirements before liability can be imposed on a defendant or defendants. It's not strict liability. I got hurt, you're responsible. And that goes into, they try and make the argument that maybe a negligent undertaking claim should apply to to Freestone County Fair Association, or maybe it was just negligence. But I think and I honestly don't know what they think should have been submitted. If they think it should have been submitted as a premise liability case and a negligence case and a negligent undertaking case, or just one of those other theories, I don't know. But I'm pretty certain of this, is that this, at least as to my client, Freestone County Fair Association, this is a premise liability case. And I think if they would have just submitted one of those other theories and not had a premise liability, I think if they would have gotten a finding on that, then we'd be faced with a situation in United Scaffolding versus Levine where they failed to obtain the proper jury findings, and it would be an automatic render if they had won and we were appealing. And I feel pretty confident as to Jason Murray. You get into the situation with Jimmy Adams, and I don't know how to explain it, but I think if you look at the trial court record, and that's in volume 10 of the record, and I believe it's in pages 38 to 42 of the record, where it is discussed on exactly what Mr. Adams moved for directed verdict on. They try and parse out some snippets where he says he never did this or he never did that, but it's pretty clear when you read the entirety of moving for directed verdict that it was only sought in connection with premise liability. That they never sought directed verdict on any negligent undertaking claim. And while I don't think the evidence as to Mr. Adams would have supported any of that, the bottom line is it wasn't sought and it wasn't granted. And if the Allreds thought that they had viable claims as to Mr. Adams on either of those points, they should have submitted a charge. And if you look at the charge conference in volume 10, they didn't. And Rule 279 says if you don't obtain a finding, it's waived. And so to Mr. Adams, and that gets into our venue issue. Directed verdict was granted as to him. So we're no longer have proper venue in Bell County, Texas. Our last point, which I think is probably one of the more novel things I've ever run across in 16 years of practicing law, and maybe the court has ever seen, is whether or not the Allreds non-suited all the defendants whenever they filed their first amended petition. When they did it, they removed all their names. There was not a defendant's name other than Jimmy Adams in the venue portion. There's not a defendant's name in the live petition. And if you go look at the case law, it's pretty clear that the removal of a name or the omission of a defendant's name is tantamount to a non-suit, whether inadvertent or not. So with that, I will give back the final 2 minutes of my time, and thank you very much.
Any questions? Thank you, counsel. Mr. Alexander? Mr. Alexander, you're on mute.
Better?
Yes, sir.
Better.
Okay,
Yeah.
thank you. Sorry. I'm going to start with the Farm Animal Liability Act. The case you need to focus on is Lofton. They are taking an overexpansive view of the definition of what constitutes an inherent risk. I stand on my description of Chief Justice Hecht's description of the hypothetical. It was a moving horse trailer. The hypothetical was, if you're unloading your horse at an area where everybody is parking their horse trailers and one of those horse trailers hits you, that's an inherent risk. That's something that you could expect to happen. Contrast with that here, where Jimmy Adams himself testified, this is something that should never happen in a barrel race. That's volume 9, page 172. This is completely unexpected. To use another hypothetical, it would be as if a truck pulling a trailer decided rather to stop where everybody else went, he would just drive into the arena. And while Tudor Allred was exiting the arena, she had a collision with that truck. That's not an inherent risk. It's not something that you reasonably expect. There's simply no way that you can look at Lofton and decide that the Farm Animal Liability Act exculpates liability here. I'd like to now turn to the question of Mr. Foreman being an attorney. I've not found any case anywhere, nor have they cited one, where someone has been disqualified from testifying about expertise on one area simply because they were a lawyer. He was not there to testify about legal questions. He would testify to ultimate facts, but as we cited in our brief, that is a classic thing for an expert to do, to be able to say that something is negligent or not negligent, safe or not safe. And that's what their expert, Ed Colston, was permitted to do. He was permitted to testify that, even though he'd never been identified as an expert, that a tie back gate is unsafe, something that Mr. Foreman would have been able to rebut and demonstrate that this was a totally avoidable accident, not an unavoidable accident. So the next thing they said was, well, he was just like the observer watching the football game. That's not true. He had put on rodeos. He'd not put on professional rodeos, but the laws of physics don't draw a distinction between professional rodeos, high school rodeos, non-sanctioned rodeos. The safety issues are the same in all of those. Wind blows, banners act as sails. And the fact that he had direct experience with that, in fact, was the only one who had ever actually seen it happen, shows that he was the most qualified person to testify about that issue. If you look at the Gamble case, the beekeeper case, you'll conclude that he was eminently qualified to testify, should not have been excluded, and they completely changed the character of this case when he couldn't. They said there's no evidence of no bulls. Look at the video. You get to watch the video again. The the bucking chute is right next to the chute she comes out of. There's no bulls. They could have had a gatekeeper. If there were bulls, he could have sat on top of the fence. So this notion that somehow that there's no evidence on that issue is wrong. They said, well, this evidence was cumulative, that Miss Jetzlau was talked about, gates never being tied back. She was a barrel racer. She was not somebody who had put on rodeos like Mr. Foreman. And so that was not a fair race. By keeping Mr. Foreman out, they basically hobbled Tudor Allred's horse in this case, and they were able to put on a case that she was not. Finally, they talk about foreseeability. They say that this was simply not foreseeable. That's jury argument. This court doesn't have to make the decision whether, if you put a banner the size of this one on the side of a gate that a single human being can close, that it's foreseeable or not foreseeable as a matter of law. The point is that Mr. Foreman could have been testified to how it was foreseeable. That should have been admitted. The question is, should he have been able to so testify? You don't have to decide that question as a matter of law. You just need to decide whether Tudor Allred is entitled to a fair trial, the one she was deprived of. And we ask this court to respectfully reverse and remand. Thank you, Your Honor.
Any questions? Thank
No
you,
questions.
gentlemen. The case is submitted and you are excused to leave. But before you do, just out of curiosity, Mr. Alexander, where are you arguing from? Do you have a bench, judicial bench in your office?
We do. We actually ripped it off from the, that's too strong. This is 2/3 of a bench that the Texas Supreme Court used at Sam Houston State when they had an audience there. And so we have it on indefinite loan from Sam Houston State, had it installed here. And so it's our moot courtroom.
Okay, I was just curious. And Mr. Bellevue, I remember you argued a couple months ago in front of us, if I'm not mistaken.
Yes, sir, Justice Quinn. I argued in the Pena versus Harp Holdings case back at the beginning of March.
Okay, time goes by fast.
It does.
And for your edification, last month we started holding in-person oral arguments. We had 2 this morning, in fact, and we're trying to move in that direction. And hopefully in the near future, we'll have the opportunity to see you in person as well, all of you.
Yeah, look forward to it, Justice. And the court clerk had actually reached out to us about being able to do oral arguments, but because of prior obligations I had on both sides is more, I'll say, my fault that we aren't there in person. Between prior obligations and just decreased flights because of COVID, just logistically, we couldn't get in and out of there and do other obligations that we already had to our other clients.
I was telling Mr. Bellevue that I'm just grateful that we didn't show up with cat faces.
I was hoping to get up there. A good friend of mine is from Amarillo, and he was telling me about a boot maker that I need to go up there and get some boots made at. So I was hoping I'd be able to swing it, but no such luck.
There'll be times in the future.
The technology worked for everyone. At times I had a hard time with the audio.
It was fine on our end.
Okay.
Sometimes it comes in and goes out, but that is part of the electronics, and that's one of the reasons I think it'd be great when we start doing these more in person. So
In person, yeah.
Well, with that, we'll let you go. You'll be excused, and we will be in recess until further date.
All right, thank you very much.